All right. Hey, Brian Parker, attorney Brian Parker here. Another exciting video. We're live streaming at the same time we're doing this. We like to experiment. Let's see how it goes. I have been asked a couple of times by a member on my member site about mediation, and that puts feelings in me about, after doing 30 years and seeing the evolution of case law as it turns into ADR and mediation and courts getting clogged up. Back in the 80s, 90s, courts got clogged up by one thing, and that was PI cases. So different jurisdictions started, with the PI case in mind, introducing mediations and ADRs to eliminate the backlog and the clogging of the courts. It was thought that that would settle cases and they'd get off the docket. Well, the tort reforms that states did kind of kicked back some of those cases, but the courts, as it happens in America all the time, something is introduced to fix something temporarily, there's money coming to it, and when the problem goes away, they keep the agency or the thing that's drawing money, and now people have this fiefdom, and that's my interpretation of what happened with ADR, dispute resolution, case evaluation, or mediation. I am going to call those three things, ADR, case evaluation, even arbitration, mediation, for the purposes of our video today. It is said that a good compromise occurs when both parties leave the table dissatisfied. As you get older, these rules that you hear and rely upon don't make much sense anymore, and that's one of them. I don't get in a case and go, gee, I want $100, hope I get 50. My client didn't ask for that because it isn't a personal injury case. So before we go on, I want to tell you a quick story. I did a ton of what's called lemon law. I was in the state of Michigan, where at the time, that's the car capital of the world. But they had this little statute that said, if you aren't happy with your car and it's had the same repair 4 times, or a number of repairs, but they had up to 30 days in the first year, and that's the original statute I went under, you can get out of the car and get your money back. Well, no manufacturer's doing that. You need an attorney, but it gave you attorney fees. So I became one of 2 attorneys. This great attorney introduced me to this thing that should not have happened inside the car capital world, but it got my clients their vehicle, out of the loan. The loan was paid off, or a new vehicle. Sometimes you could work it out with the dealer where you get such a good deal, you just go into a new deal. But that was the lemon law, right? So I'd sue. Chrysler or Ford or GM would say, all right. And if it kept going where there was a dispute over whether I met the 4 repairs or the 30 days, we'd go into this court. And eventually the court would go, okay, off to mediation you go. And it was called mediation at the time. It later became case evaluation, as everything else changes their names. And seeking the remedy of a lemon law statute, the remedy is only one remedy. Take this car back, give me my money back, and pay off my loan. And at the time, it was, you got all your money back, all the payments you made, minus 10 cents per mile at the first repair attempt. Sometimes the clients would put 15,000 miles on a vehicle and get all their money back. Great deal, but they didn't want to buy a lemon that they faithfully paid upon. So it was a great deal, but it's what's called an equitable remedy. You are seeking someone to act, as opposed to the law that says 2 + 2, you receive 4. An equitable remedy is you're demanding, out of fairness, if you will, that is one aspect of equitable, but you're asking someone to do something. So mediation would be set up just like for personal injury, and put a money number. So a guy comes in, breaks his leg as a result of a car accident, asks for $60,000, mediation settles at 40. And there's the money number. The attorney gets to the third, everybody's happy. But they'd force every case into mediation because they thought, oh, it's a great idea. I don't have to deal with this case on my docket. And what they do is, especially in Michigan, they'd say, you go to mediation, you have 28 days to accept or reject. And if you reject, you must beat the award that you were awarded at mediation by 10%, or you will be forced to pay the other side's fee. So I'd have to go to my client that's got this $40,000 wreck of a engine problem and say, hey, they gave you $12,000, and if you don't accept it, you're on the hook. So that's a bitter pill for me and my client to accept when the equitable remedy that they seek is unavailable to the mediation. So I butt my head up against mediation, and I'd fight with the mediators, and I'd tell the judge, I'd file motions. It never went well. So I have a Parker brain. My brain just doesn't see things the way, sometimes it's good. So what I did is I realized that my client's going to be on the hook if they reject and they don't beat the thing by 10%, the sanction. That's what was forcing people to accept a dissatisfying settlement. It is said that a good compromise is when both parties are dissatisfied. So GM didn't want to pay, and the client didn't want to accept money because he's still stuck with the vehicle. And if he's an honest person like we all are, he doesn't want to trade the thing in, maybe to a dealership, to somebody else with the problems they're aware of. And frankly, if he doesn't disclose those problems, maybe he's looking at a lawsuit. So that's what mediation did to lemon law cases and a number of cases that didn't fit into mediation. So I got pissed, and I discovered, and this is first rule, one of the rules of mediation case evaluation, and it's good. In every mediation or any settlement discussion, there's a specific rule that says these settlement discussions cannot go outside of the mediation hearing. Because no one would agree to settlement discussions to work on things to settle cases if it was going to be held against them. So there's hard and fast rules that say, generally, there's actually a federal evidence rule. I think it's FRE 408. It's MRE 408, I believe, in Michigan. But that's baked into 2.403 into the mediation rule in Michigan. And a number of states have, if not all, if you're going to go into mediation and have settlement discussions, it's not allowed outside of the room. So I go, well, wait a minute. That means nothing's allowed outside the room. So I decided with my client's consent that the goal was to get as close to zero as possible if we're forced into mediation. So I'd go in my shorts, flip-flops, didn't take a shower, didn't take it seriously. With my client's permission, I was telling him what I was doing. And the panel would be like, oh, is your attorney here? I go, no, I'm the attorney. And I would just beat them down, just not participate. The mediators would get mad. Some would storm out. And what they do to punish me is go, okay, we're going to give you 0. And in my head, I'm like, please give me 0. I can beat 10% of 0. And that worked for a while, but it became agitating. And that's where I come from in mediation. It never works. And I've been in different professions and discipline inside the law. Mediation rarely works.